Okay, good morning. This is the Senate Judiciary Committee. We are taking up S58. It's January 11th, 2024. S58 is a bill having to do with fentanyl. And second and subsequent offenses, selling or dispensing a regulated drug with death resulting. We have our first witness is Michelle Childs from Legislative Council, who drafted S58. So Michelle, please.
Good morning. So for the record, Michelle Childs, Office of Legislative Council, and as the chair mentioned, we're taking up the bill as introduced. And because there have been a lot of discussions since the bill was originally introduced, and I think folks have some suggested changes, I'm kind of going to do a broader overview on those sections where I think that there are a lot of proposed changes and go into a little more in depth where I think I haven't heard about necessarily proposed changes, and it's just more of a policy perspective, policy choice for you. So if you look at page 2, which is, you look at the very top for section 1. So we're working in Title 18. So usually, or very often, we're mostly when we're dealing with crimes, we're working in Title 13. But because we have Chapter 84, which is the regulated drug chapter, is in the health title, that's what we're working under. So Chapter 84. So you see the first section is amending the definition section, and these definitions apply throughout Chapter 84. So it is, so when you're looking at adding these definitions, they would apply throughout the chapter. So the first one is a definition of fentanyl. You do have, as you know, there is section 18 DSA 4233 little a is your criminal statute with regard to fentanyl. You guys have probably, I know you've been talking about this subject for a while, but you'll recall that there is not a possession offense under 4233A. It is just for selling or dispensing. And that policy choice was made when y'all added fentanyl. Gosh, let's see, what year did you add that? 2017. So I'm going to skip over that because that's, I think, one of the issues that folks are going to talk about, maybe some changes. The next one is adding a definition of knowingly. So when you're talking about crimes and you're often talking about one of the elements being the mens rea, meaning the mental state that is required for culpability under the statute. And so there are some suggested changes. I think coming on this particular piece, I'd have to double check, but let me talk to you generally about the differences. So right now, so if you have, when you think about the required mens rea, so you have like the lowest standard being negligence, then you move up to recklessness, and then you move up to knowingly, and then you move up to intentionally, or sometimes you'll see purposely. And so each one being like a higher standard, right? So negligence being the lowest, intentionally or purposely being the highest. And so you have knowingly as the standard that is used within Chapter 84 with its, so you'll see there's a very formulaic structure to the drug law. So like each, whether you pull up like cannabis or cocaine or heroin, it'll first have subsection A, it'll say possession, and then it'll be like a person who knowingly and unlawfully possesses, and then it'll have the subsection B will have for dispensing and sale, and then for a few of the statutes like cannabis, heroin, cocaine, there'll be a subsection C that'll have to do with trafficking. So we're talking about larger amounts. And knowingly is the mens rea. That's what's required to convict under that particular provision. So if you look at the Vermont jury instructions currently for knowingly, jury instructions. So so let's say, if you have a jury and they're trying to decide, does this defendant fit within the definition of the crime? And so I just wanted to read to you currently what the jury instructions are for knowingly. So if the state has to prove that the defendant acted knowingly, it said you may find that the defendant acted knowingly if the person was aware that their conduct would cause or was practically certain to cause a certain harm. So if you look at the definition of knowingly, there on line 8 on page 2, so the change here is that knowingly means actual knowledge, which means just like it says, so you actually know, you actually know that, let's say something contains fentanyl. and then you'll see on line 10, or consciously ignoring a substantial risk that one or more preparations contains that drug.
Yep. So around knowingly, given that it can reasonably be assumed pretty much all the drug supply at this point contains fentanyl, does that sort of automatically apply then?
I think, I don't know enough about you've been hearing a lot more testimony than I have, and so I think you probably want to hear from some of the witnesses and then let's have the discussion around that. But I understand the question there, which is that certainly I've heard some of the things that you have, but you've heard much more through some of these hearings, which is that substantially, large portion of the drug supply does have that contained in that.
Yeah, I guess I'm just wondering from like a legal standpoint, if that is the sort of public knowledge,
right?
Would there be an assumption of knowing?
I think that if you look at the language starting on line 10 is consciously ignoring a substantial risk that it contains that, I think you're probably on the right track.
Okay.
Yep. So again, I'm not going to, I'm sorry.
Well, just going back again to, and all I have is the Vermont lab and Tucker's report, Attorney Jones for the Department of Public Safety's report that 100% of the glassine envelopes that they seized contained some measure of fentanyl. So one could assume that either in cocaine or heroin or whatever else the drug is, that fentanyl is involved, right? I mean, that's what this is saying.
Yes, yes. And so
seller.
we know that, and they know that because they've got the lab results. The question is does the defendant know that?
And you claim you didn't know there was fentanyl in the drug.
Right.
That's what this is
right. Right. So the state would pour forth and say, well, isn't it kind of common knowledge among people who are either, substance users or selling or dispensing that these drugs are, I would say tainted, but maybe it's not, maybe it's intended to be that, contain that particular drug. And then the state would still have to prove that they meet this standard. But they would obviously offer evidence and saying, well, look, the drug, the lab tests do this, and it's known amongst the community of people who are selling and dispensing drugs that it contains this. But so they would still have to meet the standard. But
now, from a legal standpoint, that wouldn't mean they would have had to have it tested to prove they themselves.
No, correct.
Okay.
But one could assume I think that's what.
Yes.
So, is it okay for me to move on to the second one? I'll be here all morning.
It's like selling a Tesla with a bad battery.
We're just assuming the Tesla has a bad battery?
Well,
do you have a new car that I didn't know about? Do you have a new car that I don't know about?
No, I don't, but it was kind of a joke during Christmas time that, have a bonfire and buy a new car.
Okay, I'm going to move on to section 2 because I think it'll be helpful to hear from some of the witnesses why they want that or whatever, and then I can certainly work with you on working through the language that they propose. So section 2 is an amendment we have this statute, and I know it's there, but I forget about it. It's been, I looked, it was enacted in 1990. There have not been any amendments since that time. What this essentially says is that a person who's convicted of a second or subsequent offense under the drug violation, so for whatever drug it is, and it doesn't limit it to dispensing or sale. It's just a person convicted under that section, so it could be possession, dispensing, or sale, or trafficking, for those few statutes that do have the trafficking offense. That the term of imprisonment and fine can be doubled. All right, so this is a penalty enhancement for any drug offense currently under those particular sections.
Clarifying question. I think I remember a conversation last year around the terminology of dispensing. That would be like if I was sitting in my living room and shared we use together. Yes. Okay.
So that is current law, and so you'll turn on to page 3. And right now, trafficking offenses would just go under that existing law, so those could be doubled as well. But as you know, the vast majority of our offenses set a maximum term of imprisonment, right? They don't set a minimum. We do have some statutes like dispensing or sale with death resulting that has a mandatory minimum. But primarily, you see mandatory minimums on some of the more serious sexual offenses. But it's not typical for mandatory minimums. And so what the language on subsection B is doing is that for it's singling out trafficking separate and apart from the possession, dispensing, or sale.
Yeah. Question about this in general. So the mandatory minimum applies to trafficking, right?
Mm-hmm.
But it's only trafficking of fentanyl? Or am I?
No. If you look at, so the fentanyl definition is just up, it's just up in the definition section applying throughout. So it would apply to the 4233 little a.
So we're taking, sorry.
That's
Well,
okay.
you have 42, could you get us a copy of 4230A1 so we know it?
Yes. You mean the fentanyl statute?
Yeah.
Okay, sure.
Yeah, it'd be helpful to have that.
So Ben, do you mind?
So we're
just-
making an exception for fentanyl.
You're not in this penalty enhancement.
What are we doing?
I'm gonna get there. I just haven't gotten there yet.
Oh,
We're
okay.
asking too many questions, Senator Sears.
Wow,
I was just
You
trying
asked
to
all the
explain to you
questions.
what the current law is.
okay.
So that we could understand how that is changing. So what I was just saying is that under current law, there's an existing provision that I can't think of ever in my 25 plus years being here, ever talking about this particular statute that we're amending here in section 2. So I just wanted to tell you about it because, we just don't chat about it much, but there is a current statute that allows for a doubling of the penalty for possession, dispensing, or sale of the drugs that are listed in what is subsection A on the bottom of page 2. And so that's like cannabis, cocaine, LSD, heroin, so it's like those types of drugs. So if you look at B, what it's doing in subdivision B1 is it's saying for purposes of trafficking, so for those sections that have trafficking, right? So like cannabis, cocaine, heroin, etc., for a second or subsequent offense of trafficking, right? A person is to be in prison not less than 3 years and not more than 30 years. So if you look at, so I just want to make sure you're clear on the numbers. So if you look at the trafficking offenses under current law, it'll say like not more than 30 years. I think it's a 30-year felony. So it can be anywhere from 0 to 30, right? And so what this is saying is that for second or subsequent offenses for trafficking, there would be a mandatory minimum of 3 years, and then it would still have that max 30 years. Okay?
And
So when somebody responds that this is only on trafficking, it's not Senator Bahowski sharing.
No, this is all just, you see on line 1, page 3, subsection B, the trafficking, and it just applies to those particular offenses, and I'll write those out for you, and I'll write up something that can pass
And
out.
that is a enhancement
Yes,
of 3-year minimum and 30-year maximum. The
Right.
maximum stays the same, it's the minimum that's.
correct, and so, you'll hear, when you hear from the state's attorneys, they may not, I don't know how often they actually use this particular statute anyway around the doubling of penalties. But, that'd be something, I know you were asking for some information on
What's the
another
current
issue.
fine for trafficking?
It depends on what crime it is, I can look, but they're pretty high,
They're not too
I
$2
wrote the
million.
trafficking, and so you and I must have done it together, and, it was maybe 15, 20 years ago.
Yeah.
So, but I can look it up.
Said, I suppose, but 2 million sounded pretty high.
I think this is doubling it. I think that if you look at the underlying, I think it's 1 million, but I can look.
Okay.
And so that's what we can do it under. So a mandatory minimum of 3 years, maximum of 30, if you get a second or subsequent of trafficking for the drugs that are listed that have trafficking offenses. Right now, they would just go under that doubling penalty, so it would be 0 to 60, right?
Mhm.
So subdivision 2 is just in this, you can think about, this language is similar to what we have in some places for like aggravated sexual assault of a child, things like that, where it says that you cannot, you have to serve that mandatory minimum. You can't defer it, you can't suspend it, anything like that. Although you'll see then in subdivision 3, it says, however, if the court makes written findings on the record that deviating from that mandatory minimum is going to serve the interests of justice, then the court does not have to impose the mandatory minimum. Okay. So section 3 is an amendment to selling or dispensing a regulated drug with death resulting. And I think this is the section that really, I think, folks have been working in the off season to propose some changes, but generally I'll just set it up for them, which is that, as you know, you have a provision in current law that provides for a specific crime around when someone has dispensed or sold a regulated drug and and there's a death resulting from that. That is a crime that is currently, you'll see at the top of page 4, does have a mandatory minimum. It's a mandatory minimum of 2 years, maximum of 20. And then the current language you see is the unstricken language in subsection B starting on line 3. And I think what's going to be really where you're going to get into the details and discuss the policy around is like, well, is that where that knowing comes in and talking about whether or not that person who dispensed or sold the regulated drug can use as a defense or bring up the thing and say, well, I didn't know that, I thought this was cocaine, I didn't realize it had fentanyl in it. And so I wasn't necessarily, ignoring the risk. Yep.
Well, I don't know what changes. I do know some of the changes that are being suggested, but the thing that bothers me the most about some of this is we put in place 100 years ago a Good Samaritan law, 100 years ago, 2 years ago, and to see people still ignore somebody who's overdosed, who sold that drug to them, or tell somebody else to drag them out the front door, leave them. It's troubling, and so there should be, in my mind, something that gives a defense to somebody who tries to undo and makes it worse for somebody who does nothing. It would depend upon the case, but I know of a case where somebody took a drug that contained the animal tranquilizer, and the people that gave it to this person, couldn't care less that he was overdosing, except get him out. He was at a motel, and get him out of our front door. And somebody else luckily called 911. Emergency responders came, and the person was revived. But had that person died, I think it's the behavior that ensued of those who gave that person the drug that would be most troubling had that person died.
And we can certainly look at the Good Samaritan law, and then, it's a separate issue of like whether or not there's a duty to aid, and whether or not you kind of want to bring in that concept if someone sold or.
Well, I'd like to bring in the concept that if you take no action to help that person, you are then contributing to their death. At least to give a defense to somebody who actually tries to undo what happened. Yeah.
Well, so in that, I guess my question is, how do we make it clear to the public that they won't face harm? Because I imagine that it's less of a callous not caring and more of a lack of clarity about what they're gonna get in trouble for. And so my concern with making them get in trouble for more is that would actually drive them away from helping.
Well, but the Good Samaritan law, we'd have to look, we should probably look at that again.
Yeah, and I think we need to do some public education around that, because certainly when I talk to people, they have no idea. They're like, oh, no, I didn't know I could take someone to the hospital and not get in trouble. So I think there's a public education aspect of this, so that the general public understands how the Good Samaritan law
Anyway,
applies.
To tie in the Good Samaritan law at some point.
Okay,
and
we
that's
can certainly review
whether
that.
it's
Yep.
My idea or somebody else's or whatever. It just doesn't matter to me. I just want people to be aware that they don't have to drag the person away from the front door and let them die.
All right, that's all I've got.
Well, simple, well, Senator Hashim and then Senator Norris.
Michelle, did you mention that the section on proximate cause, that's the section that's being revisited and?
Yes,
Okay.
yep.
I had some questions, but if it's being reworked, then.
Yeah, I would say let's hear from
Yeah.
states of, I think the Tim and Erica are your next witnesses, and they can talk about their proposed language, and
Thank
then we can get into that.
Senator Norris.
Yes, thank you. Yeah, Michelle, we seem to have redundancy here, both on page 3, and we'll just go to page 4, under subsection 2, where we have said that there's a minimum of 3 years, not to exceed 30, depending, and notwithstanding subdivision, the court may impose a sentence that does not include the terms blah, 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 that will serve in the best, or serve in the interest of justice. Could you give me an example of that?
So that is a term of art that you'll see pretty frequently in Vermont law. Just kind of at the top of my mind, that what jumps out is thinking about like our sealing and expungement laws is one of the standards when the court is looking at if you meet certain conditions and looking about whether or not a record should be sealed or expunged. The standard that the court is that, you know, they're weighing all the factors in a particular case to determine whether or not they think, you know, something by sealing a record or something like that would serve the interest of justice. I think probably if you have since you have sentencing stuff in here, you might want to hear from the judiciary, and Judge Zone can talk about how the bench approaches that standard. But it is something that's used really throughout the statutes, and it's to give the court discretion to look at it, you know, case by case, and all the evidence in front of the court to determine whether or not, looking at the statute and the intent of the statute, whether or not it's.
I'd just like to see in real life some example of this, that when they said,
Sure.
well, no, we're not going to impose this when they had a death resulting from either xylazine or fentanyl, is it because the best interest of justice.
Well, I could ask all 6 of them tomorrow.
This
Right.
is true.
You know, I will give you just a hypothetical, and I'm sure the court can give you, and then also, you know, state's attorneys, whatever. But let's say that it was someone who is a single mother of 3 children who is employed and the sole caregiver for her children. The court may look at all the factors and look at all the risk things and say, you know, maybe it serves the interest of justice to have her on some type of supervised release so that, you know, her kids don't go into foster care and, you know, those types of things. But, so.
This is only for trafficking, correct, of any drug.
Yes, yep, on establishing the mandatory minimum.
Yeah,
Correct.
it's only for trafficking.
Yep.
Of any drug, and it doesn't.
That has a trafficking offense, yep,
Yeah, not just fentanyl. really.
correct, yep.
Any drug.
Mm,
Any, I should say illegal.
Did you have a question, Senator Boweski?
So I guess I'm just confused, if it's only for trafficking, why section 3 is here? Because that to me looks like selling or dispensing.
Oh, I thought we were talking about section
I'm talking
2.
about
okay.
B1,
B1,
Got it, okay.
yes.
where the mandatory minimum.
Right, so if you look at talking about trafficking of regular drug in violation of, so 4230 is cannabis, 4231 is cocaine, 4233 is heroin, 4233 little a is fentanyl, 4234 little a is meth.
Got it.
So-
I thought we were talking about the whole bill, and I'm like, that's not how I read the bill.
Those are the specific things, like there's
Got it,
no
okay.
trafficking offense for hallucinogens, or there's no, you know what I'm saying? So there's only trafficking offenses for certain drugs in
Got it.
current
Okay.
statute.
Yeah, but it does, the bill does three things. It deals with knowing standard,
Correct.
the mandatory minimum for trafficking,
Mm-hmm.
and then the selling and dispensing with death resulting.
Correct.
That's really what the bill attempts to do, and then it'll do more if we approve what some suggestions are. So, let's.
I actually have one quick question for Michelle, that maybe you know the answer on off the top of your head, but what are the current penalties for heroin? I'm trying to think how I want to word this. The parts of the statute that this bill deals with, I'm wondering what the analogous penalties for heroin currently are. Does
When you
that,
say analogous, I mean, what do you want to know? So,
so like section 1 is dealing with trafficking. What is the trafficking penalty? Or is there a mandatory minimum for heroin trafficking in selling and
no,
distributing?
so
with
for
death result?
trafficking for heroin, it's 3.5 grams or more, and it's a 30-year max.
Okay. And then is there a statute for heroin around the selling or dispensing with death resulting? Is there any heroin analogy?
No, so you have your heroin statute that is the possession, dispensing, sale, trafficking, and then the death resulting is its own separate standard.
And that applies to anything?
Yes, any crime.
So this would be changing that for anything, not just fentanyl?
You mean on section 3?
Yes.
Correct.
Even though there's this line that says, at the bottom that says, if the regulated drug contains fentanyl.
Where are you?
I'm on page 4, line 9.
Well, that would be there. I would say, I can't remember if what they're proposing is the new standard is specific to fentanyl or not. But the thing is that this would apply. So let's say, I guess what I was thinking of is your question is does it apply to cocaine, you know, that may have fentanyl in it? Does it apply to meth that may have fentanyl in it? All of those things.
No, my question is do we have a similar statute if someone knowingly gives someone heroin that results in their death?
Right. Well, right now the statute applies to all the drugs.
Okay.
This proposal is saying that for purposes of this statute, that you make that presumption with regard to fentanyl. And I'm just trying to see what their new language is, if it addresses that or not. And it doesn't. And so I think let's just wait because their new proposed language does not specify
There's a
fentanyl.
witness, right? It's
Okay.
just anxiously
Yes.
awaiting the opportunity to answer
Okay.
that. And his name, and our next witness is Timothy Lauders Dumont, legislative and assistant appellate attorney, Vermont Department of State's Attorneys and Sheriffs. And Erica Mockett will be following you. She's in court right now.
Did
That's
Terry
correct.
make these?
Mm-hmm.
Yeah.
Just gonna put this box right next to me.
Anybody's welcome to have Terry Corson's cookies that came directly from the courthouse.
Except you, Tim.
It's up to you, Tim.
I am sorry I'm missing the cookies, but she dropped some off at our department the other day, and I will admit on the record, I had 5 of them. I will admit that.
Did you say 5?
Throughout the course of the day, I will admit I had at least half of the cookies that were dropped off. There was great dismay displayed by multiple members of the department that they had gone missing. I can't tell a lie in front of this committee for sure. So, Mr. Chair, as you're enjoying the cookies, I did want to say Erica Marthage will join us in a little bit. She is stuck in juvenile court at the moment. And while we do have some suggested edits, which are on your committee page, the Executive Committee of State's Attorneys and the Executive Director's Office support this bill because we do feel it's a really helpful, modern approach to the facilitation of prosecution of what we would call multiple substances, as well as the crimes relating to death resulting. I will say right at the start, and sort of getting to some of the discussion you were just having, we don't take any position about the penalty section. Our focus is about the knowingly change, as we see that as being one of the most important pieces that you could do on this bill. But the goal, as we see it, is to amend Vermont's existing definition of knowingly for the purposes of drug offenses only. And that's important to recognize, as I think you've all discussed this morning, to recognize what has been referred to by courts as willful blindness, deliberate ignorance, or conscious avoidance. It is our view, and supported by the data, that anyone involved in the trade of illegal drugs knows or should know and should not be able to claim otherwise, that the product in glassine bags often contains fatal amounts of fentanyl, even if they are slight, and that as time goes on, these substances may change, the mixtures may change, the deadly substances, fatal substances may change, so that today it may be fentanyl, but in the future may be something else. And as you suggested, Mr. Chair, xylazine makes Narcan much less effective, and so the tranquilizer xylazine has introduced another more deadly angle on the current drug trade. In a case from a couple of years ago, in terms of where this is coming, the Supreme Court essentially found that under existing law, your existing drug offense knowing standard, the knowing standard really contained two components. The first component was that the state must prove the defendant knowingly sold drugs. In Vermont, that means, as the Legislative Council eloquently explained, voluntarily, consciously, and did not inadvertently do that thing because of mistake or accident. The second prong, the second prong of the requirement, as we see it, is that under existing law, the state must prove that the defendant knew what drugs that they were selling, distributing, trafficking. And this is really where we're running into the issues. And this bill helps to fix that. So when it comes to the drug marketplace, it has become more and more difficult to prove that second component of the knowing requirement because of how prevalent fentanyl has become, even if it's a slight part of the mixture, how frequently fentanyl is mixed with other substances, how infrequently actual words like heroin and fentanyl are used when drugs are being bought and sold, and how mixed drug substances are frequently packaged in very similar ways. So in early 2021, just quoting a Superior Court decision that I will not cite for the purposes of not, if our department is involved in the appeal, but I will note that the language that came out of that in a county not far from Washington was that the defendant was allowed to escape a charge in many respects because the court recognized that there wasn't an existing standard in Vermont to account for the fact that someone could consciously disregard a substantial and unjustifiable risk that they were, in fact, selling a product that contained fentanyl. The court understood at that time that the knowing mental state, as it had been interpreted by that court, presented in a substantial barrier to filing charges, given that there is no conscious disregard like language. The federal courts, including the Second Circuit, which includes Vermont, have defined knowingly in a way that really agrees with what you're doing in this bill. In a case, U.S. versus Rodriguez from 1993, the court recognized if you find beyond a reasonable doubt that the defendant was aware that there was a high probability that they possessed a drug that is a controlled substance, but that they deliberately and consciously avoided confirming this fact so that they could deny knowledge if apprehended, then you may treat this deliberate avoidance as the equivalent of knowledge, unless you find the defendant actually believed that they were not possessing a drug that was a controlled substance. So I think that eloquently describes where we're at today. And Erica Marthage, the state's attorney from Bennington, I think will talk about kind of what she's experienced in Southern Vermont. They have a drug checking program with Brandeis University. And similar to the data you'll hear from the Department of Public Safety, in the vast majority of those drugs that were, as you were suggesting, Senator Wachowski, voluntarily being checked in Southern Vermont, the vast majority of them contain fentanyl, and a decreasing part of the pie is containing heroin at this point. xylazine is on the rise in that mixture, but thinking about drugs in distinct categories in 2024 is not a particularly modern approach. It's more mixtures and what's in the mixture, and I'll leave it to the lab because, like legislative counsel, that's not my area of training at all. So I'd be happy to walk through some of the changes we recommended that are posted on your page, if that's helpful, Mr. Chair.
Mr. Chair.
Yep.
So turning to the definitions section, if you look at what's been posted this morning.
You have a question? Yeah.
Oh, sorry.
Nope, the witness was asking permission to walk through the.
Yeah.
Yeah.
Well, I'm trying to get the changes. I've run into a problem on my iPad. I can't get the internet. So Ben was gonna print copies for us.
Would you like me to share my screen with the changes?
That would probably be helpful until Ben can get the copies made
Great.
for us.
Sounds good. I will share.
Tanya, did you have a question?
Yeah, I did. So when you were sort of explaining the knowingly standard, one of the things you said is someone accidentally distributes, sells, or dispense. How does someone accidentally traffic, distribute, or sell drugs?
So what I was referring to is part of the jury instruction that legislative counsel was discussing. One of the ways that the current knowing standard plays in is that it's sort of a classic legalese type of language, but knowing includes something not by accident. So it's a kind of clumsy language, but the idea being that if you did something that you voluntarily did it and it wasn't an accident that you did it, that's the current knowing standard includes that kind of language to help explain to juries that the inverse of an accident is what voluntary and knowing is in Vermont.
Why don't you share your screen? Share your screen so we can see what the changes are, because I can't access the internet.
So I did have one other question about the knowingly standard that I don't know if it's for you or Michelle, but is in this knowingly standard as it's being proposed, does that include any knowledge of what someone's tolerance to the drug is? Because different people are going to have different responses based on their tolerance to the drug. So how am I, well, I'm not trafficking drugs, to be clear, but how is someone who is selling or dispensing drugs to know what the other person's tolerance to whatever might be in that drug is?
Yeah, it's a very good question. I'm not the right person to answer that question, but the fact is, there's certain elements to the crimes relating, and can everyone see my screen just before I answer that?
Yeah.
Yeah.
Michelle, do you have an answer?
So I think I know what you're asking, which is, so like in the context of, let's say, you're selling, right? And then it's knowingly and unlawfully selling, whatever particular drug it is there's not an element there of that. The knowing applies to that you are the actual act that you're doing with selling and that you know what that drug is.
Okay, but not that you know necessarily what impact it will have on the person.
Correct, although let me now look at the selling, although I don't have their new language around.
I mean, that from my perspective, as someone that's worked on some of these cases, it would be impossible for an individual to predict another person's tolerance, particularly because sometimes, as we've seen, that can vary depending on what's, again, I am not the right person to speak to the biological or science behind it, but it can depend. And I think that's not something that we're focused on in terms of this bill, because it depends on what's happening in a certain situation. If someone doesn't overdose, it doesn't experience an overdose, that would be a fact-specific, case-specific question, certainly.
Okay.
So
Why
looking
don't we
at
go
the
your
changes
section
that were
one, the
suggested.
definition?
We did suggest a slight change to fentanyl, and this was after surveying many of our drug prosecutors. They recommended including the language "any quantity of fentanyl," just to be clear that fentanyl, because of its, and again, this speaking in 2024, because it is so an overwhelmingly powerful substance, it can pervade over the other mix of things in the substance. So even if you look at, and I will share with you an Excel sheet of the drug checks from Windham and Bennington counties. It's all anonymized, and there's no person's names attached. It's just the ones you'll see that the mixture is all over the place in terms of what the other substances are. So any quantity of fentanyl really gets at that point, that with fentanyl, it can cause the overdose, even if it's not the only thing that's being distributed. But we would also cite that the Department of Health, if they adopt rules on what that looks like in the future, would be a good place so that it's not a move, so that it's a target that can move.
Senator Baruch, and then Senator Mahalski, and
quick
then
question.
Senator Sears.
I am not a chemist or I have no scientific training. But when you say any quantity of fentanyl, and I understand the reasoning you just gave, but wouldn't it be possible to have a trace so that there was, you know, a detectable modicum of the drug in the sample, but clearly not enough to have caused the death? Would this language, does this overshoot the mark?
In our opinion, no, because it's deemed to be about 50 times more powerful than whatever heroin was, and it really to say again, give people's tolerances are different. If someone is being charged and the substances have been tested, and it shows any quantity of fentanyl, and let's say an overdose, and let's say a non-fatal overdose, does take place, and it's charged for, and you're charged for distribution or trafficking, being able to accurately charge the cause of the harm is what I think we're focused on. So if someone overdoses this, let's say it's non-fatal, and we are able to locate through text messages and other evidence where that drug came from, we want to be able to accurately charge the cause of the harm, which wouldn't be baking soda or baking powder or chlorine or other things that are in mixtures. It would be that likely the fentanyl caused it. But as you'll see from the bottom in the death resulting change that we're recommending, the mixture of drugs, and I would defer to the health experts as to the proper definition, the mixture or any one of those things, including fentanyl, could be the cause of death. So we do think it's important to recognize any quantity of fentanyl could cause an overdose.
Okay, thank you.
Michelle has, we're gonna jump to Michelle, and then to Senator Mahalski.
So, Tim, I was just wondering, so looking at the definition of fentanyl that you have proposed, so any quantity, and then looking at the fentanyl statute for selling and dispensing, right? And so it follows the model that we have throughout Chapter 84, which it just says, you know, the more you possess or sell or dispense, you know, the penalties go higher, right? So for example, under current law, if someone dispenses or sells 4 milligrams of fentanyl, it's a 10-year felony. So in thinking about like what you were just saying, so I'm trying to think about how that new definition works with that. So if, like you mentioned, you know, I'll just use baking soda because I know what that is. But if you said, so if there was 4 milligrams of, or just under 4 milligrams of baking soda, and then a little bit of fentanyl that then made that, whatever that little pile of powder is, to equal 4 milligrams, even though it might just have the tiniest bit of fentanyl and it's mostly baking soda, does that mean then that someone would be subject to the 10-year felony? And I guess what I'm trying to sort through there is understand that the next one is like, it's a 20-year felony if you go to 20 milligrams of fentanyl. Could you still have just under, 20 milligrams and the same amount of fentanyl for that 10-year felony, and it's still filler for the others that gets you, Senator Bruce knows where I'm going, is like, how do you make, I'm trying to understand is how do you be able to sort through what you can charge under?
So
do you understand what my question is?
Oh, yes, and it's a good question. The question about amounts for fentanyl is not really the focus from our perspective here. The focus here would be if someone overdosed from any amount of a substance that also contains fentanyl in any quantity. The amounts that you're talking about wouldn't be altered unless, right? Let's say there was a substance that, I think what's important is if that is, it's a really good academic type of question, because if we can charge fentanyl under this new definition, which is just in the general definition section, I think it's possible you could do that. In actual practice, if let's say, and I'm looking at the drug samples from Bennington and Wyndham right now, some of the other products are xylazine, cocaine, heroin. I can't pronounce any of the other ones except for morphine and methamphetamine, there's a lot of really interesting substances in here, but fentanyl is an overwhelming part of the marketplace. If someone were to charge a distribution case or a trafficking case using this definition, in a hypothetical, yes, we could charge under those things. The amount of fentanyl that it takes to cause harm is just, it's on a different scale. And so I think that is what you are trying to do with this bill, is recognize that even if fentanyl is not the overwhelming part of a substance, that it could still be causing harm. So I think that's a policy question for you all.
I totally get what you're saying, and
Yeah.
I see the intention of that with the death resulting one, but I don't know how you make the charging distinction between a 10-year felony and a 20-year felony if really a few, what are they, like granules or something, it could just be added to 4 grams or this, or I'm just thinking you have a charging issue there that I don't quite understand.
So my understanding is that the lab does not measure the proportion. It measures whether or not the drug was present in the substance. So it doesn't, this block was 22% this and 30% this. Does the substance contain fentanyl or not? If the answer is yes, then we could charge.
Mr. Chair, if I might.
Yep.
So I do see where Michelle is going, and it does strike me as somewhat problematic. If what we're saying is that we're going to add 10 years to someone's sentence based on an additional amount of fentanyl, but I hear you saying that we're not going to determine the amounts of fentanyl, but just if it's present in any measure. That does seem to be in conflict with the approach we're taking in those tiered sentencing guidelines. And am I right that this definition would land?
Yes, it applies to the entire chapter.
Right. I'm very uncomfortable with that change as opposed to what's in the bill as proposed. The any amount, because I think Michelle raises one problem, but there would be others, seems to me.
My recommendation would be to remove the penalty sections and focus the bill on the knowingly sections for the purposes of what we consider to be the most important part of the bill, which would be the knowingly definition, which I just wanted to say, we think the knowingly definition in this bill is the most important part of it, and we wouldn't recommend any changes to what you already have in there because we think it agrees with the federal language. So the penalty section, we take a position.
Why don't we continue to hear testimony on this proposed section, but the concerns of several members of the committee are noted. So if we could go to, you have changes in section 2.
I don't think we have any changes in section 2 other than to say that we don't have any preference or opinion as to the penalty section. So that's not something that we're pushing or in favor of. Section 3 was where we had some further suggested changes after talking with folks in the field that are doing these types of cases. And I'll just walk through that briefly. It's on page 4, I believe, and it does relate to the death resulting section.
Okay.
So,
why don't you walk
everyone see that?
through
So this section shall only apply if the person's use of the regulated drug is the proximate cause, as you were talking about, Senator Sheen, of the person's death. the fact that a dispensed or sold substance contains more than one regulated drug, and this is the part that we've suggested changing, or that the deceased consumed more than one regulated drug, shall not be a defense under this section if the proximate cause of death is the use of the dispensed or sold substance containing more than one regulated drug, or the consumption of more than one regulated drug. And here's the part at the end that you had a question about the use of the word fentanyl. There shall be a rebuttable presumption that each substance is the proximate cause of death if the cause of the death is caused by a mixture of drugs. That may not be the proper term of art, but I think just for common conversation, that we're trying to get at is the death resulting statute shouldn't be tied to any one substance. It should be tied to the mixture.
So, Senator Bałowski has a comment or question.
Yeah, I have a couple. So back in the first section, in the knowingly portion, when you're asking the Department of Health to make rules on what is a fentanyl-related substance, do you have a sense of have you discussed with the Department of Health? Like, I don't know what that means. And I feel hesitant to change a standard like knowingly when I don't know what that means.
Previously it was the Board of Health, and now it's the Department. And I will leave them to testify on what that process is. I think the point of that was so that if they come up with rules about it, that this statute is tied to whatever the Department of Health ends up doing.
Okay, and then my other, are we bringing in someone who has a better sense of testing? Because so my other concern with knowingly is if I test strips only test at a certain amount. And so if I'm trying to be responsible and I use a fentanyl test strip and it comes back negative, but then the lab tests it with much more sensitive equipment and finds, oh, actually it did have fentanyl in it, but I tested it with my test strip and it came back negative. Like I have concern with the discrepancy in what people have access to. And then in this last portion.
Well, let's go one by one. Yes,
okay.
We're gonna have somebody from the lab here, and we're gonna have somebody from the Department of Health if we continue with that particular provision. That has been suggested. That was a new suggestion today.
Yep.
As a change, and so we obviously don't have anybody from the Department of Health scheduled. Secondly, the lab will give us, Trish Conley's always given us great information on how they do their testing, et cetera, et cetera. So those are the first two. Now your third one is?
And this is on this last portion that you're suggesting as a change, basically saying that if it's a mixture of drugs, it can be presumed that any aspect of that mixture of drugs was the cause of death. Would that essentially mean that anyone dispensing anything and someone died, they're now, it's assumed that that was the cause?
So the example that comes to mind is there was a very tragic case where 5 people at a military academy took an upper, something that they thought was a stimulant, and it contained fentanyl. All 5 of them died. And this type of language we would think would be a more modern approach, so that the prosecutors in that case were not pursuing cocaine charges, when really what likely killed those folks was the mixture of drugs, which did include fentanyl. So it would be the mixture is what we would be prosecuting as to the death result.
I'm getting extremely confused by all the questions, Tim. So Senator Hashim, go ahead, but I'm getting more and more confused because I don't understand now what you're trying to get to. But go ahead.
I hope I'm not going to contribute to the confusion here, but thanks for testifying, Tim. One of my thoughts / concerns initially for this is this section here regarding prohibiting a defense as it relates to proximate cause. And I was wondering if you could do a bit more of a deeper dive into that. And, you know, the basis for my concern is it seems like this particular section is, you know, basically prohibiting, you know, 1/3 of what has to be proven for a homicide. And I mean, you know, you have actual cause, your proximate cause, and the mental element of it. So why do you want to remove this defense?
So the approximate, this was already in the language before. We're supportive of that section there, in terms of the proximate cause piece. The rebuttable presumption piece says that it's a rebuttable presumption, so it may be rebutted, but that each substance is the proximate cause of death, is caused by the mixture of drugs. The point of that is so, I mean, and it aligns with your knowingly update, is that a person distributing, selling, involved in the drug trade in the year 2024 should not be able to claim they did not know there was a fatal substance in the mixture. And while fentanyl is the number one reason that individuals may be overdosing, the ability to prosecute in a death resulting case, the mixture is what is really important. And I think the federal government does work like this already. And I think this statute goes a long way to getting us more in line with how the federal government approaches some of these types of cases.
Yeah, so,
I just have a quick one.
yeah, go ahead.
Okay, I'm getting as confused as you are, Senator, about this. If this is such a dangerous drug or whatever, could someone, and maybe we don't have, could someone explain to me where did fentanyl come from and what was the purpose it was supposed to be used for? If even a trace of this could possibly kill you?
I think,
You might be able to.
Okay,
Anna might be able to.
I'm not a chemist either, let's not too bad.
that's why he's here. Great. Tim, there's obviously a lot of confusion created by B that you have in front of us right now. And maybe you could either try to simplify it or make it so even somebody like me can understand it.
So previously, B just related to fentanyl. And the last line says, you say, if the cause of death is caused by fentanyl. Often what we've seen on, I think, the reports from the lab is that it says something along the lines of mixed drug intoxication or mixture of drugs. When fentanyl is in that mixture, we would like to charge it as aligning with what's actually occurring, which is that the lab is saying mixed drug intoxication, the mixture doesn't contain fentanyl. But let's say in 2 years, there's something that's even more deadly than fentanyl. We would then have to come back and update this again. Instead of saying if the cause of death was fentanyl, we'd have to then substitute in a new thing or create a new section. This allows for us to more closely align how death
So I don't think you have to wait 2 years. I think you can do it today.
Sorry.
The animal tranquilizers that I can't pronounce, but I guess they call it track, or something like that.
Yeah, but we'll be back here updating it in 2 years when something new is on the market to get around these laws.
So, and these, I mean, the intention of our changes.
Before you jump in on me, my sentence was, would this allow prosecutor to use this if track was, and I don't know if I'm using the right term, by the way, but the animal tranquilizer was found in the compounds and mixtures?
Yes, it would allow for the cause of death to be the mixture of drugs.
That's helpful. Thank you, Senator.
And I know we're gonna move on and we'll tease these apart as we go, but the last sentence, am I reading it right that what you're saying is if there are 5 substances in the sample, there's a rebuttable presumption that each of the 5 substances is the proximate cause of death?
I mean, I think that's the way to read it, given the way that we've seen these cases come about. Yes, it could be. Yes.
But my problem with that is, it seems like we're basically saying we don't know, but we're going to say that every single one of the substances in here caused the death, and then we'll put it on the defense to rebut all of those presumptions. So one of the substances, as we've talked about, might be, baking powder. But this language would seem to say that there's a rebuttable presumption that baking powder was the proximate cause of death. So it just seems like the net is being cast so wide here from that first question I had about any quantity of, any trace of fentanyl, and then with that, you're saying that we're just gonna say whatever happens to be in the glassine bag is a cause, approximate cause for death, and there's a rebuttable presumption thereof. So I understand you're trying to cover all future cases, but it just seems extremely broad to me, I have to say.
So something along the lines of mixed drug intoxication or mixture of drugs is what we're receiving back from the lab or from the that analyze. So that's what we're trying to tie it to instead of a substance at a point in time.
Yeah.
Anything else, Tim?
No, I mean, I'll just say that State's Attorney Marthage can talk about what's co-occurring with the drug distribution, drug sale, in what she's observed, and that I think our goal, and I appreciate, I'm not taking it personally, the criticism, because I think our goal here was to assist the aims of what we thought that we were trying to do.
Right. I appreciate that, and, we'll continue the conversation. But I think we've heard a number of concerns about Section 3 and the changes that are proposed here. Obviously, Section 4 will have to be changed too if we pass the bill.
Well, thank you, Mr. Chair, and I think State Attorney Marthage will be available, and the last word would be that the knowingly standard is the most important thing here. The other things, if I had to prioritize them, that they would be, I'm not speaking on behalf of individual prosecutors, but me personally in front of you, the knowingly standard needs to be updated, and the other things we can certainly continue to work on.
Thank you, and I'm gonna go to Lieutenant Casey Daniels from the Narcotics Investigation Unit of the Vermont Department of Public Safety. Lieutenant, thank you for being with us today.
Thank you all for having me.
Well, then we'll go to Erica Marthage after we take a brief break.
Let me introduce myself. Thank you all for having me here. My name is Casey Daniel. I'm a lieutenant with the state police. Currently, I oversee the narcotics unit drug task force in the state of Vermont. I've been working as a...
Is that a change of name or?
The NIU Narcotics Investigation Unit was originally like the state police, and then the drug task force when we kind of merged into
back in the day. Colonel Birmingham was the head of the drug task force, and that is now your position.
Correct, sir.
No, okay. That helps.
So I have about 25 years of work experience in law enforcement. 20 of those years, approximately, are around narcotics investigations. So at the beginning of my career, when I came into the drug unit in 2003, was kind of like the bubble of the Oxycontin era, Percocets. So I've had the unfortunate opportunity to see a lot of what's transpired throughout the 2 decades and the opioid dependent people that were on the Oxycontin and Percocets merging to the heroin. And that was certainly an issue. And then where we are today with the fentanyl and xylazine is just completely turned upside down. I have some statistics I want to share, but I don't want to forget, this may be helpful for what this discussion was earlier on the confusion. With any of the overdoses, fatal overdoses, our lab does not test for potency in substances that they get to the lab. However, the autopsy that would be performed is going to be much more specific as to what actually caused the death, if that's helpful in any way. Mm-hmm. So if I go back to 2015, percent of cases containing heroin was 100%. Percent of cases containing fentanyl was 8.48%. If we jump up to 2023, the percent of cases containing heroin are 34% now, and 98.4% fentanyl. So there's fentanyl in everything. I don't think we've had a case in the last 2 years, and speaking in the drug unit, where it hasn't had some compound of fentanyl. And to piggyback on that, with the xylazine, in 2021, we obviously just tracked this since 2021, 12% of the heroin and fentanyl cases contained xylazine in 2021. Last year, 58%, 55.8% of heroin and fentanyl cases contained xylazine. And
55%?
55.8, sir. Xylazine is irreversible. You can't take Narcan, naloxone, and like you can with fentanyl or heroin. It's a sedative used by veterinary clinics, and it does not react to naloxone.
And recently in Bennington, there was a lot of that xylazine in the crack cocaine or cocaine traffic. And obviously, so have you tracked that as well?
The xylazine,
In the cocaine.
But in fentanyl, I mean, we're seizing cocaine with fentanyl. We've had incidents where people overdosing.
One's it up and one's it down.
Correct. So cocaine,
Why?
cocaine, methamphetamine would be a stimulant. Heroin, opioids are downers.
Excuse my ignorance, but why would you want to put a down into an up or an up into a down?
The people using it aren't anticipating that it's going to be in there. Fentanyl's cheap. You can buy a kilo of fentanyl for an eighth of the price you could a kilo of heroin. And then you can cut it much more and get much more yield because it's so much more potent.
But Senator Maroof mentioned baking soda, and I think back in the day, didn't they used to use those types of compounds?
Yeah, baking soda and inositol. There's several fillers that are used in that.
They're still used today.
Yes.
Yeah, and that would be the case. So they would have a little bit of cocaine, a little bit of fentanyl, and then some inert substance. But the fentanyl might be in there to give people the illusion that there's more of the drug that they think they bought than there is.
Correct.
Yeah.
And then you have the my perception, I can't speak to quote this, but you know, you add an opioid to anything. It's kind of like the whole McDonald's putting you know, whatever it was, heroin or cocaine in their meals to get people to come back because they want more, that dopamine level, you know, drive. It's the same, I feel, the same concept with drug trafficking organizations. They want more customers, they want repeat customers.
Sure. Senator Bohowski has a comment.
Yeah, I have two questions. So one of them, so I know xylazine is not reversible with naloxone, but can it be reversed in a more controlled setting through airway securing and oxygen and sort of allowing it to pass while not letting someone die?
I don't think I'm the one to
Okay,
answer that.
fair.
I don't have a medical background.
Fair.
To my knowledge, I don't believe so.
Okay.
I think CPR is about the only thing.
And then, well, and then in terms of the drug supply, are you seeing an increase in benzodiazepines or nitazines or some of the other adulterants that we're seeing on the West Coast? Has that started to trickle into our supply as well?
I think Dr. Conti would be.
Okay,
a
perfect. Both of
person to
these
ask
are
that
questions for the doctor.
Yeah.
Thank you.
Please go ahead.
Okay. So in the past year, the Drug Task Force has worked tirelessly in the state, of course, both federal and state drug laws. And within the last 3 years, we've responded to all drug-related homicides with the Major Crimes Unit. Last year, the Drug Task Force increased our workload in controlled sale cases by 17% compared to 22. Arrests went up 30%. And the most concerning stat is our firearm seizures went up 57% last year, which is a lot. The state police current functional vacancy rate is 25%. The Drug Task Force currently has 14 members throughout the state, 9 state police personnel, along with 5 vacancies we're holding because of obviously our issues with hiring.
Well, you go ahead and then I'll ask my question. Go ahead.
Just a quick clarification for the firearm seizures. Did you say 57%?
Yeah, it was 57%.
57. And I don't doubt that, some of these are related to drug trafficking, but do you have a breakdown of how many of these firearm seizures were related to drug trafficking versus other crimes?
All of them.
All of them were, okay.
Now, these stats are just for the drug task force,
Okay.
okay? This is not statewide municipalities, the uniform division and state police, it's just drug task force.
Okay.
That was my question, was in the drug task force previously, local and county, members of law enforcement were involved in the task force. Are they still, or is it just all state police?
Yes, sir. Nope, they are. I was just getting to
And
that.
how weak is the Southern Vermont? No, that's a bad question.
Leading question.
How many openings are there in the Southern Vermont Task Force? My understanding is it's fewer than they used to be,
For locals or for state police?
both.
For state police, we are down 5 positions in the drug task force for trooper positions.
Okay.
For locals, we have full capacity. What we have, we can allot for the CDIP money that funds that. We have 4 throughout the state. 1 is out of Bennington. We have 1 out of Newport, Franklin County, and Morrisville.
My sheriff is interested in.
I spoke long terms with Sheriff Billy.
Okay.
Yeah.
He used to be on the drug task.
Yep, he did.
Years ago, back when before he became before he became sheriff.
Yep.
He's concerned.
Yes, we talk frequently. Actually, one of his deputies is now out in the drug task force.
Oh, good, you solved the problem for me, thank you.
We're trying, sir. So the functionality rate, we've added 2 analysts to 2 of our units from the National Guard, which is, these cases are complex. There's a lot of phone data compared to a decade ago, 2 decades ago, that you had controlled buys and you got a lab result, and that was pretty much it. It's much more complicated now. State CDIP funding supports 4 municipal officers statewide. There have been inquiries from other local departments to participate. However, our CDIP funding for these positions have not been increased since 2014, so we're limited on how many people we can bring in. I won't go over. I think I was going to talk about the knowingly line in page 2, line 8. We've had situations where this has come up in some of our cases, and the judicial system not finding probable cause.
You find that those changes would help?
Absolutely.
Would you say that's the most critical part of it?
Yes.
From your perspective?
One of them, yes. Yes. In 2023, 44% of homicides in the state involved individuals that had a drug nexus. Most of these guns seized in the state are from larcenies, residential break-ins, motor vehicle larcenies, or straw purchases by mostly opioid users. Opioid-dependent individuals are stealing and purchasing these firearms when trading them for opioids to drug trafficking organizations throughout the state. Many of these guns show up in homicide, not only within Vermont, but Massachusetts, and also Connecticut. We have incidents in the state finding guns, firearms, and drugs on people during search warrants, arrests, without being able to charge these individuals. This has been a challenge for us because of the current Title 18 4253. If these people aren't Brady disqualified, they're 20 years old, on a street gang in Springfield, Massachusetts, we can't charge them with anything because they possess a firearm. They can legally possess a firearm in Vermont as long as they're not Brady disqualified. If we run the gun and it comes back stolen, we could potentially charge them with a misdemeanor possession of stolen property. We are running into a lot of cases. Most of our search warrants are yielding firearms and drugs, or cocaine, fentanyl based drugs. So having some support in possibly that bill, I know I'm getting a little bit off topic, but I want to share our experiences, allowing us, the definition
This is
says,
the ghost gun.
No, this is the use, this is a standing statute. It says for the purpose of section, use of a firearm shall include the exchange of firearms for drugs.
Yeah.
But the use, again, using the terminology, if you're not using it or robbing somebody, you just have it. You're not using it, but you're still in possession of it. We're seeing a lot of that in the last 5 years increase. I have some examples where I think this bill would apply to that we've seen in the last year. Carrie Yu is a Vermont resident who was convicted of fentanyl distribution in November 2023. She failed to appear on numerous state and federal drug-related charges, which yielded an arrest warrant. In December 2023, VSP received a tip for her location. The search warrant was executed. Carrie was found to be hiding in a closet in possession of a loaded stolen handgun, 21.27 grams of methamphetamine, and 58 grams of xylazine. That's 2 ounces of xylazine. Also, her 8.5-month-old child was in the camper with her at the time of her arrest. She had conditions and 12 law enforcement involvements within the last year. Within the last year, we've noticed a severe uptick in the xylazine presence in fentanyl. And I gave you those stats earlier with what we're seeing with the xylazine. And like we said, xylazine is not reversible. Another example from the Rutland Herald, Rutland felon charged with stealing possession of a $2,000 firearm from a local lawyer got a quick lesson on Wednesday about what the difference between bail laws used for defendants in Vermont and federal courts. Nicholas Karov, 38, was ordered jail after a federal prosecutor noted the defendant had 35 criminal charges pending in state court. He had 18 earlier cases of failure to appear in various court hearings in Vermont. Kimberly Bouchard is one of our most vivid and recent examples of recidivism and escalation in criminal behavior. In March 2021, we began an investigation into Bouchard distributing small amounts of crack cocaine in Franklin County. After controlled purchases, we arrested Bouchard in January 22. Bouchard was immediately released on conditions and received information that she continued selling as soon as she got out. In March, we were able to continue our investigation, conducting numerous controlled purchases of cocaine base and fentanyl. She was in with an associate, Zakwan Roy. At the time of the subsequent offense, Bouchard was subject to conditions of release again and previous offenses. On May 2nd, she was arrested again and released on conditions. On June 4th, 2023, both Bouchard and Zakwan Roy were involved in a drug-related homicide in Leicester this past year. At the time of the homicide, Bouchard was on court-imposed conditions and released for both sale cases. And one in Rutland, this is from the Rutland Herald. Nicholas Ranglin pleaded not guilty on Friday in Rutland Criminal Court to 2 felony charges of sale of cocaine. Ranglin's history in the area, which included drug arrests in 2015, 19, and 20, convicted in 2021 for felony possession charge, and was out of prison on probation. A month later, there was a case generated in the Fairhaven area, controlled buys, and he was released again. So it's just like this continuing systemic releasing of these individuals. So interestingly, I just want to throw this out there. We were talking about fentanyl, xylazine, opioids. The increase in dopamine levels in crack cocaine is very similar to the dopamine level increase in opioids. And I don't want to forget about the crack cocaine, because that is still a very big problem in the state. Certainly not contributing to as many overdoses, fatal overdoses and non-fatal overdoses, but is still, we're seeing the burglaries, the retail thefts, a lot of that is from the cocaine base and the opioid dependencies of the cocaine base. Whether systemic retail thefts, burglaries, controlled substances, substance distribution, these are a small majority of the individuals creating most disruptive behavior in our communities. As we've seen, conditions of release are only effective if the individual takes it seriously and they're held accountable for violating those conditions. Many individuals learn that after they reoffend, and the only repercussion is more imposed conditions, the seriousness of the court order conditions is deemed ineffective. Based on what local police departments across the state are seeing, a select few of individuals fall into this category. And I'll use Rutland, Brattleboro, Bennington, for example. It's not all the people that are opioid dependent out creating these crimes. It's 5 to 10 people that are continuing these crimes over and over and over again that we're seeing anyway. Vermont is now what it was a decade ago. We do not see the violence and the drugs that we do today. We heard of these incidents in larger cities in the past, but not in Vermont, not in smaller communities. And now we're seeing them almost daily, if not weekly, occurring in our state. So the Vermont State Police does support this bill. A few changes that we encounter in the reoffending rate of these select people and communities. Vermont drug statute penalties seem to be relatively comparable to the other states. I don't think the penalties are really a focal point necessarily. However, what we are seeing is these penalties are not being imposed by the judicial system. They're charged, but they're ultimately not getting the penalties recommended. And we feel that finding a way to merge law enforcement, prosecutors, defense attorneys, the judicial system, and certainly the recovery treatment providers is essential to effectively provide a quick response for people in need of treatment, which would lessen the demand for opioids coming to the state. Also, protecting the Vermonters from the criminal activity that shadows some of these individuals is equally important. It is imperative that the drug trafficking organizations coming to our state to profit off this crisis are held accountable in our state and federal court systems. And that's all I have.
Can I have a question about in the Bennington area, there are a number of places that have been identified as drug houses. Some of them are single family dwellings, some of them are apartments within an apartment building. The last year in S4, I can't think of the act number, but the governor signed the bill and we put in provisions where the landlord could be held liable if they did nothing to try to deal with that. Are you running into problems with those types of facilities, and is there something that we can do to help you to? I mean, the neighbors, the other apartment dwellers. I've got more complaints from neighbors about a particular single family dwelling in Shaftesbury than I have about other places, but I'm sure you know the location. I know the street, but I forgot the number, but I've gotten it several times. So is there something we can do to help with that problem?
Yeah, and this is just only my opinion. I think, I have.
That's all we're asking for is your opinion.
Okay, well, then I'll give you my opinion about that. So I am a big proponent of the crack house statute. But, that comes to prove like the landowner or landlord or homeowner is involved or completely negligent on correcting the problem. I get phone calls from landlords, parents, about what you're talking about daily, if not weekly. And the other part of that is the landlord laws are so tough. It's hard for the landlords to get these people out when they know there's a problem. And that's been a real challenge for a lot of the landlords that I've spoken to on the phone, because they'll call and they'll say, I'm trying, but these people are still dealing drugs. I can't get them out. I can't evict them because of all the protections that these folks have under the landlord-tenant policy.
But if there was domestic violence, you'd be able to get the person out of the house, right?
Long term, I'm not sure we could.
Well,
Temporarily?
The court, temporarily removes people for domestic violence.
Right.
I wonder, Michelle, if there's a similar way to if to look at that particular statute.
I feel like putting something, giving the landlords a little bit of wiggle room on if they can prove, or if there was a search warrant there and drugs were seized, giving them a little bit of leverage to be able to actually evict those people would be very helpful in a lot of the situations that I hear about anyway.
It is. I got a copy of an email to the bank because they hold the mortgage on a particular building. That the neighbors are trying to get the bank to foreclose. Correct. I don't even know if they paid the rent, or paid the mortgage. So you're recognizing that as part of a problem.
Absolutely.
It's almost daily for you, or at least weekly. Thank you.
Thank you.
Any other questions? Yes.
I'm curious about just the interstate component of this. Do you have any data that you're able to share about how many or what percentage of these offenses are applied to folks who are coming from outside of Vermont to traffic in Vermont?
Offenses as far as our cases, or sorry, it's a vague question. I'm just trying to get more of an understanding of what's coming from other states and being trafficked here, compared to the individuals who are already here and distributing. Okay, I'll try to answer that.
Okay.
That understanding. So a lot of the Vermonters, the Vermont residents, I guess, that own homes or rent homes here, are providing housing for a lot of these individuals coming from, states like Connecticut, Massachusetts, is primarily now. Once in a while in New York we see. So they'll let them stay at their house. In return, they're getting drugs for allowing them to stay at their house. It's, we have the demand side and we have the supply side. Vermont is a demand side for guns, or a supply side for guns, excuse me. But the demand is here for the opioids. I mean, we could go out and arrest 10 people, 10 traffickers a day, and they're going to be backfilled by more traffickers because it's such a lucrative business. I mean, a lot of these folks from other states are making upwards of $20,000 a week. That's average, I would say, on selling fentanyl and heroin up here, crack cocaine. But it's the folks that are allowing them to stay in their houses continuously, and we've arrested those people, and they go back and there's somebody else there the next day.
Senator Bowski and then Senator Knowles.
Yeah, I have two questions. One about this sort of interstate thing that's happening. That's a federal crime, yes? So is there cooperation with the federal, I imagine it would be the DEA on navigating that?
So no. So the Vermont Drug Task Force, we have all of my sergeants, the sergeants that work for me, are deputized FBI agents. Okay, so we do our own federal cases. We don't rely on any other federal nexus to bring those to the U.S. Attorney's Office. We have direct contact to the U.S. Attorney's Office. And what we try to do is balance that. I would roughly say 25% of our cases go federal, 75% stay in state. Or if we have repeat offenders, which we've seen quite a bit, at that point we may say, this person, maybe we'll try to push them federally because they've had such a systemic following in the state system. Let's do a federal case. So we go direct with the U.S. Attorney's Office on all of our cases.
Okay.
But we do work with FBI, HSI, ATF, DEA.
Okay, that is really helpful to just have an understanding of how that interplay happens for the non-law folks in the room. I was like, no, it's across state lines, it's federal. So that's helpful.
Sure.
And then my other question, and maybe it's just surrounding states, but do you have a sense of other states that have passed similar laws? Like do Massachusetts, Connecticut, do they have similar laws like what we're talking about on the books?
I don't know if I would be the best one to answer that. I would be not 100% if I answered that.
Okay, that's okay. Thanks.
Maybe we could find somebody who can answer that.
I bet we can.
Senator Norris.
Yeah, thank you. Quick question. Senator Sears had alluded to the landlords and so on and so forth, the housing problems, and you basically said, yeah, there's a problem there. And what I'm wondering is, has the task force or any law enforcement entities that you're aware of, because I spoke to people who have been in these, homeless people who've been in these motels, hotels, whatever. Is there a problem as far as folks coming up from out of state, getting these rooms, dispersing their illegal substance from those rooms that, in that reference, the state of Vermont is paid for? Have you seen any of that in the state, in the southern part of the state?
It's very prevalent.
It's very
And it's what it is, they're not coming up directly getting those rooms, but it's the Vermonters that are allotted those rooms, that are allowing them to come into and stay and essentially sometimes take over that room.
Yeah. Okay, thank you.
That was the other piece that I don't need to ask now, but we had testimony last session about Bennington and people essentially taking over apartments with guns and threatening harm to the people in it, staying there for a month or more and then leaving. So just another aspect of the problem.
And I will add, like, I've been doing this job a long time, and the escalation in violence, some Vermonters, but majority of these young folks from Massachusetts and Connecticut, I have never seen anything like it. I mean, they are ruthless. And to see that in the state, I grew up in the state, right? So it's shocking to see that type of behavior out here.
It's interesting, and I don't know what the laws are in New York compared to Vermont, but the same problems existing in the Tri-Cities area, Albany, Schenectady, Philly. You know, most of our news in Bennington comes from Albany. And the daily reports are of, so one of these incidents that you just described. So it's not just, I think it's important to understand, it's not just happening in Vermont. And the demand is so great, you put it well, the demand is so great that these are really criminal enterprises. You know, I'm sometimes wondering if the RICO statutes could attach to some of these groups. That's more in Tucker Jones's territory, but I've often wondered about that because they really are criminal enterprises.
Absolutely.
To call them gangs was probably a misnomer.
And I feel like if we don't control the demand or the demand, then we're not gonna be able to control the supply.
Okay, so Senator, final question.
Oh, no, I'm good, thank you.
Okay.
Oh, I know you had a question. All right, we're gonna take a 10-minute break and try to see if we can get Eric out of the agenda meeting. Tucker Jones.
I can go if Eric Martha just.
Yeah, I don't know what her work schedule is like today.
Sorry about that.